recognised by New Zealand Lawyer as 2021's most influential lawyer. So if you're going to be listening to any lawyer today, you might as well be listening to the most influential one. So Brent, without further ado, please take it away.
Thank you. All right, so look, I thought I'd just get started by a little bit of an overview of what we're seeing out there in the market at the moment with insolvency and how that is going to impact business moving through the year, because I think 2020 got a bit of a bad rap, but 2021 is, I think, where there's going to be a lot more problems. And so, you know, even in the best of times, 63% of companies fail within 5 years, and so that's pretty high number even in the best of times. And we are heading into some fairly uncertain times, and you know that it's pretty obvious that there's going to be a lot more companies that fail this year and next year than have in the past. And the reason is last year there were 50% less liquidations than the previous years, and that was driven by, or mostly by, the fact that there was a lot of free money slushing around with wage subsidies and interest-free loans. But probably the biggest reason is that the IRD basically put a bit of a moratorium on enforcement of debts. Not all, but they certainly chilled out a bit. And what we saw is, as a result of Grant Robertson giving the IRD the ambit to slow down enforcement in April last year, we had 50% reduction in IRD liquidation applications. So they were not going out there enforcing as they previously did. And so practically what we saw is insolvency work just dropped straight off a cliff, because the IRD enforcement is usually the catalyst for people who are operating insolvent businesses either liquidating themselves or being forced into liquidation. This year, the IRD are in excess of their pre-COVID numbers for liquidation applications. So they're not only enforcing at numbers they were before, but they're up by about 20 to 30%, depending on the month. So they are catching up at the moment. And they're targeting the companies that not only have debts, but are not current in paying their debts as well. So people who are getting a deeper hole month by month are the number one priority. And so as a result of that, we can see our IRD negotiation work and our insolvency work has just had a very, very steep incline. And we can see that there will be about 550 companies go into liquidation this year that are in excess of the usual numbers, which sit at about 2,000 companies a year fail. So there is going to be more insolvencies this year, more formal insolvencies this year. And what we see practically is what I always call the domino effect. So one company fails because whatever reason, and they don't pay their creditors, and then their creditors fail because they can't pay their creditors. They needed that money to then pay. So it creates these dominoes, and you see it every time a decent size, say, construction company fails. It's probably the most classic example. Stanley Construction went into liquidation, what was it, about a year and a half ago, maybe 2 years, in Matamata. It was a very sizable company down there. And since then, we've just been talking to all the subcontractors because they didn't get paid from Stanley, and now they can't pay their debts. And so it just creates these dominoes, and those dominoes can sometimes take a year to fall. And so because Kiwi business owners, we like to put our head in the sand from time to time, and we'll leave it there as long as we can. So I think if we know that, if we know what's coming, then you can make proactive choices in your business to avoid being put in those situations. And look, biggest prevention to being in that situation is to not extend credit at all, but obviously that's not practical for us all. But so you know, get as much money up front as possible. That would be best practice, but you know, practically that's, like I said, that's not always possible. So a bunch of protection mechanisms that you could use is looking at security. So if you're supplying any goods, making sure that you have a very good contract in place, and that contract allows you to have a security in the goods that you're supplying. So what that means is if the company fails, you can go in and you can go take your goods back, or you're entitled to a preference over the proceeds of the sale. So say your debtor had already sold those goods, you're entitled to go in and access the bank account and take the proceeds of the sale. So it gets you ahead of other unsecured creditors. The other thing is personal guarantees. So a lot of, in the debt recovery work that we do, either there's no contract signed, or if there is a contract signed that doesn't have a personal guarantee. And I highly recommend having a personal guarantee. I find the biggest resistance to it is the creditors like, oh, people don't sign PGs, so I don't want to lose the business, and so they don't incorporate it. What we do is we put it under a heading called liability for payment, and it talks about liability, and in those paragraphs it says the person who signs this as a director trustee is also personally liable for the obligations of the principal debtor. And you know, probably 95% of the time, that, or probably more actually, that would go through no problem. And the reason is, again, when you read a contract, what do? You look at the scope of service and how much. And that's common of most people who read contracts. They just want to know, what are you doing and for how much? And they skip all the rest. And so, you know, you could get a personal guarantee very, very easily in most cases. And if it's a problem for someone, then you have an upfront conversation around, well, you know, why can't you give one, and what else can we do? And then you can choose whether or not you trade without one. And you know, if you want the deal, then you can cross it out and proceed. The other issue that I see cropping up from time to time is if you're in the business of leasing assets, there's some fish hooks in that space, and particularly if you don't define the term. So if you don't say, right, we're going to lease this, whatever it is, say vehicle, for 2 months, or it's more than a year, then you need to make sure that you've got provisions in there that retain title to that asset, and also you register that on the Personal Property Securities Register. One thing we see all the time, and we've seen it with PC lease companies, with forklift rental companies, with scaffold companies, you name it, we've seen it. They have an uncertain term and they just define, right, it's an X amount per month lease. And if that company, your debtor, goes into liquidation or receivership, you lose your assets. And the receiver will come in and say, right, because it's a lease of an uncertain term or more than a year, the bank security, or whoever has a GSA over the business, and there's usually one in there, that takes priority over your interests. And that always comes as a massive shock, because it seems so strange. It seems like it shouldn't happen, but that's the legislative framework that we have around leased assets. And so, and it's one that I see people get wrong all the time, and it can be really, really hurtful. I'm dealing with one at the moment, which is a scaffold company, and it's a big site. It's a lot of scaffold, and it was an uncertain term, and they're looking like they're going to lose probably about 60% of their scaffold stock. And you know, it's a massive hit, not just on the replacement value, but also the opportunity cost of having those that scaffold out there generating income. So that's some preventative stuff or preventative steps that could be taken. When it comes to accounts receivable, I think in 2021 we have to be a bit more proactive than in previous years. If we know that there's going to be more failures in the economy, and it could be a great client, it could be someone you've worked with for years, but if they don't get paid, you're not getting paid. And the reality is, squeaky wheel gets oil, and I always say it, but it's so very true, and so it's really, really important that you don't let things drag on and that you are the squeakiest wheel in their life until you get paid. Because I just see it time and time again, the people who are following up on a more ad hoc basis, the people who are, who don't have a process in place, are usually the ones who don't get paid. So it's probably useful just to talk about a few steps that can be taken to increase your chances of getting paid. The first is, having a contract in place, having a good contract in place, and like I said, it'll cover off some of the issues we've talked about before. And also, if you've got a good contract in place, make sure you follow it. So countless times I see people talk about how they're going to do things in the contract, but they don't actually do them in real life. So the classic one is they say, right, any variations to the contract must be in writing. And then they go on site and they shake hands and nothing is in writing, and then there's disputes later, and then you end up talking to someone like me and it just gets really expensive. So it's all avoidable. Make sure you have a good contract, you follow its terms. Remove barriers to payment. So you can have direct debit, you can have credit cards, you can automate follow-ups for the first part of the process, but after that, I highly recommend every business has a accounts receivable policy that says at this date I'll do this thing, and follow it. So who's going to contact them, when are they going to contact them, at what point does it go to a debt collector or a lawyer, is it 60 days, 90 days, how long is too long? Get very clear in your business around those dates, and have a policy in place, and be very clear. If they don't pay, what are you going to do? Is it large enough where you're actually going to go to court, and you're going to push down that path, or are you just going to go to a debt collector, or what are you actually going to do, and make those decisions at the beginning, because it's stressful if you're not being paid, and if it's your money. Obviously, you're emotional about it, and so you don't want to be making the decisions on the fly. You want to have all of those decisions logically made up front, and then you just follow your process. And if you have a process, you're much more likely to get paid. So for example, for most business debts, we've got a very clear process when work comes our way, which is we issue a demand letter. 9 times out of 10, our client is not paid on a demand letter, but we issue it really just to change conversation, because the debtor is used to delaying. They're used to making promises or making excuses, and that buys time. So we say in our demand letter, if you don't pay within 5 working days, we're going to issue a statutory demand. And then in 5 working days, when they inevitably don't pay, we issue the statutory demand. And so we've just kept our first promise. So we said we're going to do something, and we did it. And then the statutory demand, it says if you don't pay within 15 working days, which seems long, but it's a period of time you have to use, then we're going to file liquidation proceedings. So you've got the debtor sitting there. We've just kept our first promise, and now we've made another one. And the next one is we're going to liquidate your company. And when I come back to squeaky wheel, the squeaky wheel gets oil. Now, if you're the one who has the power to liquidate their company, who do you think the squeakiest wheel in their ledger is? It's you. And so, because one thing that we know is that if the debtor owes you money, they owe a ton of other people money. They never owe money just to one person. So they're juggling, and you just want to be top of their list to sort out. And in my view, filing liquidation application is the best way to become their priority. Obviously, we don't want to liquidate. We're just using the process to leverage just a bit of pressure on them so they pay. But also, the amount has to be big enough to justify taking those steps as well. And I come back to the contract. So any good contract needs to provide for your recovery of your legal or debt recovery costs, because the last thing you want is to go to a lawyer, you're owed, say, whatever it is, $10,000, and then you get a $2,000 legal bill, and then you get $8,000 and your margins chewed up. So your contract should say that if there's any default in payment, the debtor is liable for the actual costs incurred in recovering the debt. So that allows us to go and get $12,000 and then pay us 2 and pay you 10, so you get a full recovery. And it's something that a lot of people miss out in contracts. Probably, the contracts we see, probably 50% of them have it in there. And it's not really good enough, because it can really change the outcome for business owners if they have it in there. So COVID has had a large impact on businesses, particularly in certain industries, but it's not all doom and gloom out there. So I don't want to ruin your whole day. There are a lot of businesses that are doing really, really well as a result of COVID and as a result of some of the changes that have happened. And look, there's been some really positive changes that have happened. I mean, we're meeting on Zoom, and pre-March last year, no one was doing this. I mean, this was not something that people did, and that for me, the only reason I had a checkbook was because the Ministry of Justice, you have to pay by check or at the counter, and so there was no online way to file documents or pay. And so as a result of COVID, what actually happened was the Ministry of Justice had no way to receive payments, so they just waived all payments. So we were filing tons of documents and had no filing fees, and that was great. But they eventually put in place some really great systems, and now we can file documents online, and I can throw my checkbook in the bin, which is good because banks are cancelling them anyway. But there's a lot of improvements and innovation that's happening, and so what we're seeing as a result of that is we're seeing a lot more shareholder disputes, which again could be avoidable. And what I see in the pattern of clients that we have is the hard conversations have not happened up front, and so it's all been they've got the same vision, they want the same outcome, but they haven't talked about all the hard things. And so what inevitably happens is there's someone in the business who gets more clients, does more work, manages more staff, or whatever it is, and they start feeling like, well, I should get more because, hey, I'm the rainmaker here, I'm bringing in the work, and why are we still doing 50-50? And so that kind of can start to fester when there's money. And so when you're in the trenches and you're building a business and there's lots of challenges, I generally find people band together and there's no problems. It's when there's actually money and the business is doing really well. And so my recommendation to anyone who is taking on board some co-shareholders or business partners is have all the hard conversations. On my website, I've got like 10 talking points that I recommend people work through, and to make sure that everyone is aligned, and then from there make sure it's in a robust shareholder agreement. So you can go to a lawyer and you could pay probably somewhere between $2,000 and $5,000 for a shareholder agreement, chances are it'll probably be a template with your name on it, because that's what lawyers generally do. So, make sure it's not just a template. Make sure it's an agreement that is based on a bunch of hard conversations around how you intend everything to happen moving forward. Like for example, in templates, I always see this classic dispute resolution clause that talks about, we're going to talk in good faith, and then, if we can't resolve it, we're going to mediate, and it's all mandatory. Think about the process for dispute resolution. I mean, do you want to have to mediate for every single dispute you have? And the answer is probably no. Mediation is great. I love it. It's a really, really good forum to resolve disputes, but it's not something that you should bind yourself to for every single kind of dispute, but that's what you get in templates. And a good shareholder agreement can be worth its weight in, well, not its weight, it's probably pretty light. I was going to say worth its weight in gold. But a good shareholder agreement can substantially change your outcome. I'll just give a quick story. One of our clients had an agreement with his co-shareholder that said, if you're a defaulting shareholder, you must give your shares back to the non-defaulting shareholders for the same price you paid for them. And then the agreement defined what default was. And it includes some serious things like breaching your duties under the Companies Act and stuff like that. And our client shareholder stole some money, thought he was entitled to it, so he just helped himself. And that could have triggered, and it was a lot of money. It was a 7-figure sum, and over about 6 years. And, that could have resulted in 24 to 36 months of legal bills going through the High Court process if those clauses were not there. But because the clauses were there, he was able to just come in and take the shares immediately. So a week later, he had his shareholder out of his business. And the amount that the defaulting shareholder paid for his shares was zero because they were given to him earlier in the business. So it was just over very quickly, saved hundreds of thousands of dollars in potential legal fees. And I contrast that with someone else who doesn't have it. I'm dealing with another matter where they don't have those kind of provisions. Similar behavior has happened, and we're working it through the High Court process. And to date, I've been acting for them for a year and a half, and we've just been unable to settle because their expectations are extremely unreasonable. And so, having good agreements are an investment, not an expense. And I think that's probably where I think us as business owners need to change our mindset a little bit, because a lot of business owners see legal documents as expenses, and they try to avoid the expense, and that's when you can get problems a couple of years down the track. So sorry to ruin your Friday. Doom and gloom, that's what we do. But look, I think there's some tips in there to avoid having to talk to someone like me on a more formal basis, and that's always a good thing. So that's me. I'm happy to answer any questions if there's any questions.
Hi, Brent. Malcolm here. How are you?
Good. How are you?
Good. What's the process, the simple process for registering a security on the Ppsr?
Oh, it's very, very straightforward. It's the system was designed to be used by business owners, not lawyers. So you can go on to the registry and you can get some step-by-step instructions and just follow those through. It's pretty straightforward. Most people have people that do it a lot will have an admin staff member on the team that does it routinely. It's pretty straightforward.
Cool, thank you.
No problem.
Brent, if you've got a contract, an engagement contract, and you put a clause in about if you're engaged by a company, the directors guarantee.
Yeah.
Do the directors have to initial that clause?
No. No.
So as long as they sign the contract, that clause that is valid.
Yeah. So there was a lot of uncertainty and I suppose misunderstanding around what's actually required for a personal guarantee. And for a long time, people were making directors sign it twice. And it was like sign once for the company and once as a guarantor. And that, I suppose, created unhelpful conversations because now the director's sitting there going, well, I don't want to sign that part. And so you'd inevitably have a scale of conversations that you don't want to have. But no, all that's required for a personal guarantee is that it's in writing and it's signed. And so the clause is obviously in writing and signed at the end and is signing in both capacities.
Great, thank you.
No problem.
Yeah, hi Brent, Andy here. Great presentation.
Hi. Thank you.
Just is there some kind of minimum level where it's not worth going down the track of issuing a stat demand?
Yeah, absolutely. And I think that minimum level is, a business decision for the business owner. So, like from a legal perspective, you can issue a statutory demand for any debt over $1,000. So that's your absolute minimum. But in most cases, issuing a stat demand for $1,000 is not economical. So, you've got the costs of doing it. So it just comes down to, how much are you prepared to spend on collecting this debt, and that's a business decision for each business owner. So for smaller debts, I would just recommend giving it to a debt collector, and they have a model of just hounding them, just picking up the phone, calling, all the time, emailing them, putting defaults on their credit ratings, and until they pay, and you go, stat demand path for anything larger. What also affects economics is whether or not you can recover your legal fees. So if you've got a smaller debt, it's less likely to be economical to issue a statutory demand if you can't recover your legal fees together with your debt.
Great, thanks.
Brent, it's Garth. In the past, when I've been helping business owners with their business, if they've had invoice funding, it's often been put in place because they don't have decent terms and conditions for collections of their debt. And I've worked through them to improve that side of things. And it's given me the impression that invoice funding is not a good thing. But recently I'm hearing from our accounting friends that it is a good way to improve cash flow or to get collect debts quickly. What's your opinion of invoice funding? Is it a positive thing or is it a negative thing?
It entirely depends on the business and who the funder is. Let's give a couple of examples because there are some absolute sharks in that invoice funding space, and the hidden fees and opportunities to get screwed are pretty high. When you're dealing with some funders, so when I get a client who's dealing with certain funders, who I shouldn't name, I see that as they're on track to engaging me in 6 to 12 months on an insolvency basis. And because it's just they're just getting their margins constantly chewed up, and the hidden fees don't help. I was speaking to an unethical funder recently, and I said, "Oh, it's a shame this didn't work out because the debtor company went into receivership." And the funder said to me, "No, this is a great result. I'm going to buy the business off the receiver." And part of his model was he extends funding, so he does numbers, and he knows in a year they're going to default. He'll put a receiver in, and you'll buy the distressed assets. And that's happening that's happening in New Zealand right now, and it's happening at a scale that's concerning. But then there's some. I met I met an invoice funder recently whose fees, I haven't done any work with them, or I don't know anyone that's done any work with them, but the fees are 2.7%, and there's nothing hidden in there. And my first reaction was, is this too good to be true? But on the face of it, it all looks really good. And so, if the fees are reasonable, then I think it can be a really good thing to do invoice funding, because especially when you're dealing with large corporates, some of them make you wait 90 days to get paid, and you've got to pay all your stuff, and you've got expenses, and so cash flow can be a really big problem. And so for businesses that have cash flow problems, and again, assuming the fees are reasonable, it could be a really good thing as well. So it does depend in a large part on the business that would be dealing with.
Thank you, Brent. And of course, alongside that, although I've only ever got involved when the arrangement's already in place, but I would be advising any business owner thinking of going down the track of invoice funding to have a discussion with their accountant and their lawyer before they sign the documents.
Yeah, absolutely. I mean, I'd probably recommend in the first instance a discussion with your accountant, because especially if it's, a lot of small to medium business owners don't understand their margins very well, and to really understand the long-term impact of the arrangement is more an accounting question. And then if that makes financial sense, then take the document to their lawyer and get advice.
Awesome, thank you.
Brent, from a debt collection perspective, if you go into one of these arrangements whereby you offer through a third party the ability to fund the services over 12 months, it has a recourse clause in there. 6 months down the track, the client defaults and they do a clawback. Is there anything from a debt collecting perspective that's got some fishhooks around that?
Are you talking about a liquidator clawback?
No, sorry.
The funder?
Just the funder does a clawback.
So I didn't quite understand the scenario.
So let's say, for example, a client, we offer through a third party that they can repay our charges over 12 months.
Yeah.
Then the third party has a recourse clause in that agreement. 6 months down the track, our client defaults with them.
Yeah.
They do a clawback.
Yeah.
Does that affect our ability to recover the balance?
So assuming it's been funded, the funder would need to do the debt recovery. So they would usually have the rights to pursue that. And I've seen a lot of funders pursue debts, but ultimately, if they don't get paid, then you could have a crack in trying to get paid. But if you don't, you need to pay the funder back, and it can be a pretty hard situation to be in.
Yeah. So the fact that we've financed it at some stage doesn't affect our ability to take action to recover the clawback amount?
Sometimes it can, because some of them are structured as an assignment. So some of them are actually an assignment of debt to the funder, and then it's the funder themselves that have the entitlement to pursue the debt. And the ones that take assignment generally do pursue the debts. But if they look at it and go, look, I'm not really that keen to invest in it, then they would give it back to the original creditor, and then the original creditor would be able to pursue it. But that would need to be, a fairly upfront conversation with the funder. But it's not a hard conversation, because everyone's interests are aligned. I mean, everyone wants to get paid by the debtor. So yeah, it could be something that can be done.
Thank you.
Yeah, hi Brent, Andy here again. just regarding personal guarantees, obviously a lot of my clients have to sign personal guarantees with merchants and things, otherwise they don't get supplied. Is there any way of avoiding that?
No, not for your clients. It's, they go to placemakers, and there's a PG, and if they go to Bunnings, there's a PG, ITM. I mean, everywhere is going to ask for a PG. So I would have thought it's quite hard to get out of PGs with those kinds of companies. What I would say around PGs with merchants like that is, so because I've seen this a few times where you have a construction company, it has two directors, they sign the trade terms, they agree to the PG. 2, 3, 4 years later, one of the directors resigns as a director and leaves the business and sells shares, whatever. And then 1 or 2 years later, Placemakers comes knocking on his door and says, hey, the company owes us $400,000 and you've got the PG. And he says, no, I'm no longer a director, I've resigned. I resigned a couple of years ago. And from their perspective, it's like, no, you've got the PG. And so what I would just say, for anyone signing PGs is actually just create a spreadsheet, that you keep track of any personal guarantee that you've given, and then when you resign, you can terminate those PGs. So you can go to Placemakers and say, I'm withdrawing my PG. Any further trading you do from this point is without my PG. So you need to go get other arrangements. Now you can't withdraw it for anything previous. So any trading that's happened up to that point, you personally guarantee, but you can withdraw it for future trading. And then they need to go and deal with whatever guarantees they need to move forward. Because that can be, and I have seen that, I've seen that crop up a few times.
Great, good advice, thank you. Can you limit the value of the PG that you give, or is it just an open-ended thing?
Yeah, absolutely. And for a lot of people, that negotiation is had. I mean, when you're talking about the Placemakers of the world, I think just practically they probably would refuse a limited guarantee, but I mean, you can ask. But I know, like, for example, my lease. So when I negotiated my lease, I didn't want to give a personal guarantee. So I said, look, I'll be the worst lawyer in Auckland if I didn't follow my own advice. So I really can't give this personal guarantee. Landlord didn't buy it. So what we ended up agreeing is a 3 months limited guarantee. So I'm personally liable for 3 months, but that's okay. So if Norling Law goes into liquidation, which it shouldn't, then I'm only liable for 3 months of my lease. And for a lot of commercial parties out there, they will agree to limited guarantees.
Awesome. Cheers, mate.
Okay.
Cool.
Yeah. Brent, that was good. A couple of questions. One was like, if you're on the receiving end of that domino effect, so upstream that's a big supplier has fallen over, you see it coming. Is there any way of dodging that one, or are you just basically in the pipeline and it's just a matter of waiting it out until you get troubled by it?
If you see it coming, I definitely come back to what I said before, which is try to get ahead of it, get paid before all the dominoes fall. But if a company, if your debtor goes into liquidation, I mean, the chances of getting paid out of a liquidation is extremely slim in most cases. So yeah, it's really just preparing for what's going to happen. So often the conversations that we're having for the person down the chain is around restructuring. So it could be that the business is viable, the business is, from a looking forward basis, the business is viable, but because it's got this legacy issue where it hasn't been paid and therefore can't pay, we're saying, well, maybe we need to look at restructuring. So this company goes into liquidation as well, but then we move the business over to a new entity so we can keep trading. So the business can survive another day, even though the legal entity can't. And so, I suppose contributing to the dominoes really is the best way to survive.
Cool. The other one was, you said before, the big increase in insolvency. Is that particular with different industries? Is there some outstanding industries? I mean, I imagine hospitality and tourism sectors are being hit pretty hard with COVID, but is that in line with that, or is it?
Yeah, I mean, I would expect there's going to be a disproportionate amount of hospo tourism businesses in those numbers. I haven't seen it yet though, but that would be my expectation. To be honest, the number one industry that we work with is construction, and we see a very large number of construction companies going into liquidation. And there's just so many reasons why that could happen. We see people getting into business probably too early without the skills to run a business. So they know how to build a house real good, but they don't know how to price a job. So you get underpricing, you get sloppy variations being done, and this I could talk for ages about the possible issues, but for whatever reason, there's a large number of construction businesses that do fail.
I mean, for construction, is there, like they build a whole string of houses and then there's a fault with them and it comes back to haunt them. Is there a limit to how long that takes, or if they start a new company, is there?
Well, there's when it comes to that kind of stuff, so the normal limitation period is 6 years, but there's this late knowledge period. So you've got 3 years after the time you became aware or should have become aware of the issue. So, if there's a defect in the building and the homeowner finds out, 8 years later, they've got 3 years from 8 years to pursue the building company. I know a developer actually who liquidates every development company once he's finished. Because he finishes the project, money in, money out, liquidates it. So he ring fences those those potential claims, and he's the kind of developer that you don't want developing either. So there probably will be claims in the future. So there's a whole bunch of stuff like that that's happening.
Do your due diligence, eh?
Yeah.
Right.
And pick a good builder. I know.
Yeah.
And a good lawyer. Sweet. All right, guys. Well, that's a very comprehensive session. Thanks so much, Brent. That was plenty of knowledge packed into just shy of an hour. So definitely, if you do want to learn more or need some further more professional advice, then please do get in touch with Brent Norling and Norling Law. And they can definitely help you out. Obviously, the session is recorded as well. So if you want to go back over, recap anything, then it will be made available online. So what we'll do is a bit short of time, but just take 30 seconds to just introduce yourself, tell us quickly what you do, and then we will wrap up the meeting. So I'll just start with our Andy, the man with the thumbs up. Go ahead.
Yeah, hi, Andy Burrows, trades coach. So as what Brent mentioned there about a lot of builders get into business who are great builders but don't really know how to run a business. That's what I do. I help them fill in the missing bits of the jigsaw puzzle and help them build a business that isn't likely to become a customer of Brent's on the negative side of it.
Awesome. Thanks, Andy. Jeff.
Jeff from Hughes Judd Accounting, full suite accounting firm based in Birkenhead. Our ideal client is anyone who has to deal with the IRD. We always say, spend your time making money, not reporting on it.
Okay, thanks, Jeff. Diane.
Hi, everyone. Diane Costello from AppWorks. We do mobile apps, and if you have a membership-based subscription, then notifications are good for you. If you want to cast to TVs in hotels or motels or have a camper van, then we can provide a utility service to help you with that. Thank you.
Cool. Malcolm.
Oh, good morning, everybody. Malcolm Jensen. I am a business coach with Business Success Partners. So kind of in your area, Andy, but work as part of a national organisation. We tend to work with SMEs in the kind of 1 mil to 5 mil bracket. And there's quite a few of those in New Zealand. So yeah, Malcolm Jensen from Business Success Partners.
All right. Baptist.
Good afternoon, TNG. Baptist here from Tax Advantage. Thanks, Brent, for the nice presentation. Anybody struggling with their finances, be it be tax, accounting, or bookkeeping, we are there for you. And we'll also help you out to find out what is the best way of financing, whether it is invoice financing or mortgage financing or whichever, we will find it out for you. That's Baptist from Tax Advantage.
Cool. Judy.
Hi. I have my own company, which is BizSpace in Kirikiri, where we host TNG meetings. So hi, Melanie. But that company sort of wasn't so much of my interest today. I also work for my son, who is in the construction industry, and also getting into development. So quite a bit of what Brent was talking about was obviously very relevant for us. So yeah, I picked up a lot on things that I can see we haven't got in place very well as far as contracts and variations and things. I know that's where we're probably being left open. So yeah, that's why I wanted to jump on and pick up on that today.
Awesome. Ken.
Yeah, thanks, Brent. We are at Ken Jackson, the Mortgage Lab. I have been seeing people are looking longer at the longer term rates now. Economists are starting to predict the interest rates are going to go up next year. The exact time is yet to be seen, but it's being more risk averse, and the longer term rates starting to become more attractive. Ken Jackson, the Mortgage Lab.
Cool. Thanks, Ken. Garth.
Well, thanks, Dan. Thanks for organising the Connect NZ online. It's awesome. And Brent, thank you. The hour went really well, and we could probably do with another hour sometime in the near future. It's just absolutely awesome that you're able to share with us your knowledge and wisdom. I'm Garth Partridge. I'm the National Groups Manager for the networking group, helping our TNG members get even better results from their networking. Thanks again. Cheers.
Cool. I'm Dan, so I run Ingot, which is a digital design studio. So we definitely primarily work in that web space, so helping businesses better communicate themselves online. So getting a deeper understanding of what they're trying to achieve, what functionality they require, how their business is growing, and what they need in their online space to get them to that next level, and then build that in for them, whether that's custom functionality or integrations with third-party software that they use. It's all about simplifying their process and obviously better communicating to their target market. So all on a nicely beautiful website that's created for them. So that's what we do, Dan at Ingot Digital Design. And then we have Melanie, who's riding in a car. And have you got any parting words?
Really nice to see everybody today. Thanks so much. I just wanted to let you know these recordings are all on our YouTube channel. So it's the networking group, and I'd really like you to subscribe to the channel. So when we put these recordings up, you will get them straight away. And also, if any of your members